Hello and welcome to Gough Square Live. My name is Kingham and this is Jonathan Kirk KC, and we're both barristers at Gough Square Chambers specialising in consumer and trading standards law. And today we are going to be talking about time limits, specifically statutory time limits in regulatory offences, which has been a thorny topic and one which always attracts a lot of attention. So without any further ado, I'll hand over to Jonathan, who will start our talk. Do send through any questions you might have. We'll be monitoring them and we'll try and answer as many as we can at the end. Over to you, Jonathan.
In many of the trading standards cases that we're involved in, it's argued that the prosecution is out of time. The question we want to address today is, why do statutory time limits for criminal offences create such a problem for trading standards? We think it's primarily because there is a confusion about when the time limit starts. There are a number of candidates. Is it when the complaint is first received and logged by a local authority trading standards department? Or is it when the trading standards officer investigating first investigates the case? Or when the defendant is identified? Or simply after the investigation is completed? Or is it when a decision is made to commence prosecution? We hope that we can give some kind of an answer to that question, but as you will hear, not all time limit provisions are the same, and it is useful to start by considering the two main types in typical trading standards offences. The first type of provision is a discovery provision, and these apply in the majority of consumer offences that trading standards prosecutes. For example, the Consumer Protection from Unfair Trading Regulations 2008 or the Food Safety Act 1990. So a good example of that would be Regulation 14 of the 2008 regulations, which reads, "No proceedings for an offence under these regulations shall be commenced after the end of the period of 1 year beginning with the date of discovery of the offence by the prosecutor." That should be contrasted to evidential sufficiency provisions, an example of which is Section 31 of the Animal Welfare Act, which reads, "The date on which evidence which the prosecutor thinks is sufficient to justify the proceedings comes to his knowledge," so that would be the prosecutor's knowledge. So we have there an example of the two different types, evidential sufficiency and discovery. The first case that we want to draw to your attention is an old one. It's called Brooks and Club Continental. It was decided 40 years ago by the High Court in 1981. And it concerned a simple prosecution involving a holiday brochure for the south of France, which it was alleged had a false statement in it. It said that the hotel had a swimming pool, the consumer went on holiday to the south of France, he thought he was going to get to swim, and then when he arrived at the hotel he found there was no swimming pool, and so reported the matter to his local trading standards department, and there was a prosecution brought under the old Trade Description Act, which includes a very similar provision in relation to time limits to the one I read to you in relation to the Consumer Protection from Unfair Trading Regulations. The prosecution was for recklessly making a false statement about a service under Section 14 of the 1968 Act. The magistrates in the case found that the time ran from the time of the complaint to the trading standards officer, which meant that charges were not brought within a year, and so it was out of time. On appeal to the High Court, that court upheld that all the facts material to found the relevant charge were disclosed to the appropriate officer. So what can we glean from that case? So firstly, in reporting the matter, the complainant had correctly identified the defendant company, and secondly, it told trading standards about the representation and the fact it was false. So all of the material facts were known to the officer. Thirdly, the fact that trading standards the trading standards officer had got himself into a tangle over his understanding of whether the defendant was correctly identified was considered to be wholly irrelevant by the High Court. And in the case, fourthly, it's not clear whether the Trading Standards Officer was the prosecution decision maker. So what can we summarise the case as having decided? Well, it is essentially this: where a complaint is made, the defendant is correctly identified, and the gist of the complaint is disclosed, that is sufficient to trigger discovery. Robin.
Yes, well, thank you, Jonathan. We'll take that concept and that summary that Jonathan's just provided and apply it in a different scenario. So the next case is called Tesco and Harrow London Borough Council, and that was a decision of the High Court from 2003. And that case involved a consumer who had purchased some bread rolls from his local Tesco, which turned out to have metal wire embedded in them. He telephoned his local council to complain about it, and a receptionist took his message. She then telephoned the relevant Trading Standards Officer the same day and left a voicemail message for him explaining that she had just received this complaint. The officer returned to his desk later that day, received the voicemail message, and then picked up the phone to telephone the consumer to ask about it. But the consumer wasn't actually in, and the officer ended up discussing the case with the consumer's wife. 4 days later, the officer went round to the consumer's house and took control of those bread rolls, which were then sent off for analysis, and unsurprisingly, when the analysis came back, it suggested that they weren't fit for human consumption. When the case eventually made it to court, the defence argued that the case had been brought out of time, and the question for the court was, well, when had the offence been discovered? If it was discovered, for instance, on the day that the officer had his initial telephone call with the consumer, then the offence would have been out of time. But on the other hand, if it was later, that 4 days later, when the officer physically took control of those bread rolls, or perhaps even later than that, when the lab analysis results came back, which confirmed that the bread rolls weren't fit for human consumption, then the offence was in time, or would have been in time. The High Court heard the appeal and held that the offence had in fact been discovered on that first day when the consumer telephoned the council to inform them of the complaint. And the main point to take away from this case is that discovery of the offence doesn't necessarily involve any investigation or an assessment of the evidence. It's purely a question of when the basic facts were brought to the prosecutor's attention. Now, as an aside, the case did leave open a number of points which we at least think are interesting. For instance, the court didn't specify whether the offence had been discovered by the administrative assistant when she spoke to the consumer, or whether it was when the officer returned to his desk and received the message, or whether it was when the officer actually picked up the telephone and spoke to the consumer's wife, because all of those things happened on the same day. So it didn't matter which of them started time running in that case. But you can easily see how those three steps could have been spaced out over 3 separate days, and how that would cause a headache for prosecutors, and it indeed does in other cases to this day. Which in turn means that our advice for prosecutors is clear-cut. You should assume that time starts running as soon as your authority receives a complaint. We've noticed, for example, that some local authorities calculate time limits from the day a complaint is allocated to a particular officer, rather than the date that the complaint was actually made or received by the local authority. And I don't think it's fair to say that that's at least a safe approach. As a basic point, if you err on the side of caution and assume you have less time rather than more, then you won't be caught out by those sorts of technical arguments.
Okay. The next case we want to have a look at is a case, also a High Court case, called Donna Key in Cardiff Magistrates Court. This is a case that had a number of issues and will be familiar to many of you. The basic facts are that the defendants were alleged to have clocked, an old term I know, reduced the odometer reading on a car, and then sold taxis in the Cardiff area. And prosecutions were brought for applying false trade descriptions under the old section 11A of the Trade Descriptions Act. Section 19 has a discovery of the offence time limit in the Trade Descriptions Act, and it was argued that it was in time because the prosecutor was the person authorised to lay the information, and he'd only discovered the offence when the evidence file was passed to him. The High Court rejected that argument and made a number of important findings. Firstly, the High Court found that the prosecutor was the local authority for the purposes of Section 19 of the Trade Descriptions Act, and not the person with authority to make the decision to prosecute. The High Court found that to hold otherwise would defeat its very purpose. And the High Court also determined that discovery occurred when its officials had knowledge sufficient to found a reasonable belief that an offence had been committed. So in summary, the focus of a discovery provision such as Section 19 of the Trade Descriptions Act was upon when local authority could be deemed to have had sufficient information about the gist of the offence. Robin.
Yes, and that raises an important point, really, which is that actually the identity of the prosecutor will potentially vary depending on whether it is an evidential sufficiency provision that you're looking at and whether it is a discovery offence. Because if it's a discovery offence, then, as Donna Key tells us, anyone at the local authority can start time running potentially because the material facts have come to light of the local authority or come to the notice of local authority, whereas in an evidential sufficiency provision, because the prosecutor actually has to apply his or her mind to whether or not there is sufficient evidence to prosecute, it means that there will have to be an identifiable person with that responsibility in the local authority who has to make the decision, and it's only their knowledge then which will start time running. Worth noting, as an aside, there is another case which we won't be dealing with today called Dudley, which came to exactly the opposite conclusion that the High Court did in Donna Key. So to say that it's a bit of a muddle is perhaps an understatement, but we at least are of the view very much that Donna Key represents a better analysis of the law and is the approach which we would advise trading standards authorities to take. An illustration of this, of the evidential sufficiency time limit and the difference in the identity of the prosecutor, is found in an RSPCA case called RSPCA and Johnson from 2009. And that case involved the prosecution of a dentist who was alleged to have caused unnecessary suffering to a thoroughbred racing stallion called Hans Christian. The time limits argument in that case arose under Section 31 of the Animal Welfare Act, which, as Jonathan noted at the outset, is an evidential sufficiency time limit. And the district judge in that case found that the case had been brought outside of the relevant time limit. The High Court ended up allowing the appeal and concluded that even though the prosecutor was the RSPCA as a whole, sufficient evidence was required in order for time limit to start running, which in turn meant that there was a degree of judgment that had to be in the mind of the person making the prosecution decision, and as a result, time did not start running until that person who had that responsibility and was able to exercise that degree of judgment was aware of the material facts. So, as I say, an illustration of the distinction between discovery offences and evidential sufficiency offences.
Another RSPCA case that is of importance here is a case called Crown and LaMont Perkins, which is a High Court decision from 2011. The RSPCA there prosecuted the defendant over mistreatment of several dogs. It's primarily a case about the conclusive nature of the issue of a certificate issued under Section 31 of the Animal Welfare Act of 2006. And it should be noted that in most of these time limit provisions there is the capacity for a local authority officer to self-certify that a case is within time. The High Court there held that such a certificate, although it's stated to be conclusive, could be challenged on the basis that it is either plainly wrong on its face or fraudulent. The later cases don't talk so much about fraud but misconduct. That challenge, if it is to be taken, should be taken as part of the criminal proceedings rather than as a separate judicial review. And this is an example of the courts being reluctant to have proceedings going on for judicial review at the same time as there are criminal proceedings. And so in summary, the position is that it is advisable, we would say, to issue a certificate because that is likely to deal with many of the arguments that are raised, and there is a statutory presumption that should be conclusive. However, you can't just issue a certificate where that's plainly wrong, and if the certificate is plainly wrong on its face or in some way arrived at in order to overcome allegations that the case is out of time and therefore abusive, the courts will intervene, and the court that will intervene will be the criminal court trying the matter.
The next case to mention briefly is called Barrow and Warwickshire. That was from 2015, and another High Court case, again involving Section 31 of the Animal Welfare Act. That was a case involving a farmer who hadn't taken reasonable care of livestock. And really, in many respects, the significance of Barrow is simply to confirm the approach in Johnson that the prosecutor is the person with the responsibility for deciding whether or not the prosecution should go forwards. And so until that individual is made aware of the relevant facts and is able to apply their mind to whether or not there is evidential sufficiency, then the time cannot start to run. The other key point to take away from Barrow is that the High Court confirmed that you can in fact issue a certificate after a challenge to a time limit has been raised. So it's not the case that you have to necessarily issue the certificate at the same time that you lay the information. It's a perfectly valid approach to lay in information, believing it to be in time, and then if challenge is made to the relevant date by the defence, then the prosecuting authority can issue a certificate thereafter in order to shore up that element of the prosecution.
So you can see that as we go through the development of the case law, that the way in which an evidential sufficiency provision is to be assessed is very different to the way in which a discovery provision. In the case of the Crown and Woodward, which is a 2017 case, much more recently, directors and slaughtermen of an abattoir were investigated by the Food Standards Agency. So it's important to understand this case from the perspective of the different prosecutors. The case was handed over by the Food Standards Agency to the Crown Prosecution Service for prosecution, and an issue arose as to whether or not time ran from when the Food Standards Agency investigators realised that there was sufficient evidence, or the Crown Prosecution Service prosecutor determined that there was. This case is very important because, as we know, now territorial jurisdiction for the prosecution of criminal offences throughout England and Wales has been opened up by paragraph 46 of Schedule 5 to the Consumer Rights Act of 2015. And so there will be situations where one local authority will consider the evidence in a case, but then pass it on to another authority, perhaps an authority with specialism in that particular field, or another authority which has resources to bring the prosecution. And so it's an important point for us. And so
the High Court there held that the Food Standards Agency investigators were not a part of the prosecution, and that the Crown Prosecution Service lawyer was the prosecutor for these purposes, and therefore the case had been brought within time. So it is an important decision in relation to investigations where the original prosecutor is not the prosecutor who brought the charges, who brings the charges.
The last case, which we'll talk about briefly, is called Malik. It was reported in 2021. Judgment was actually handed down in June of 2020, but it was somehow overlooked by a lot of people working in this area. But it's worth mentioning because it's a really helpful prosecution case on time limits and continuing offences, which I know is a topic that can often cause problems. The background facts of the case aren't really relevant to our discussion today, but by way of very quick overview, it was a CPUT case involving parking services at Gatwick Airport. And the key part of the judgment is found in paragraph 16, where Lord Justice Coulson said, when he was talking about continuing offences, that where there is an ongoing continuing offence, the 12-month time limit is not triggered by the first time that the offence occurs, but by the last. So in that situation, there was a website that was making misleading claims to consumers on the internet, and the website was shown to be up over a long period of time. The trading standards officers investigated the case whilst that website was still on the internet, and the key part being that even though it was charged over a continuing period of time, the 1-year time limit clock didn't start ticking until the offences actually stopped and the evidence of that website came to an end. So it's, as I say, a really helpful prosecution decision there that perhaps makes time limits not quite as strict as sometimes people might think.
So what are the principles that we can take from all of these cases? I think the first principle that is important is that not all statutory time limits are the same, and different principles will therefore apply in relation to the two main types, those being discovery time limits and evidential sufficiency time provisions, so different proposition for each. For trading standards, the most important provisions are discovery provisions that appear, for example, in the CPUT regulations, and in relation to those, time will begin to run from the date of discovery. It's arguable that this is later than the date on which a complaint is first received by local authority staff, but it is sensible practice to treat that as being the start.
Excellent. Well, whilst we've been talking, hopefully some questions have come in. Jonathan, if we're able to check, have we got any questions?
So we do, yes.
Yes, okay. Jonathan, do you want to take the first question?
Sure, yeah. So the first question we're asked is, we've been passed a complaint by another authority. Can we assume that time started running when they referred the complaint to us, or when they first learned about it? So that actually is helpful because it's one of the topics we've considered. I think the answer to that is time will start to run when the prosecutor first discovers the offence, and the prosecutor here will be the individual local authority. And so, although a complaint was received first by one local authority A, and if it's passed on to local authority B, then on the basis of the authorities that we've looked at, time would start running again. But a note of caution, that's based on the Food Standards Agency case, and I can well imagine that an argument might be run that was abusive, where it was done only to overcome a time limit. And so, although there is good authority that time limits start again when a case is passed between local authorities, be aware that that's likely to be subject of an argument that it's an abusive process, particularly if it's been solely done for the purpose of avoiding a time limit.
The second question we've been asked about is this. We missed the deadline for prosecuting under the CPUT regulations, can we still go under fraud? Can you answer that?
Yes, okay. Well, it's interesting actually. This is something that we've encountered a couple of times just in the last year, and in fact I've argued this point in both Magistrates Court and the Crown Court. Unfortunately, neither of them set precedent, but in both cases it was held that that was not an abusive approach to take, and that it was open to the prosecution to do just that. And I think so long as you've got the evidence to support dishonesty, to support a positive allegation of dishonesty, and you can support the allegation of fraud, then there's nothing improper about pursuing that case, and there's nothing to prevent you from doing so. But I don't know if you've got a different view, Jonathan.
No, I don't. And the question is really whether or not you have sufficient evidence of fraud. I think in those circumstances, regardless of the time limit having expired in relation to other offences, and as long as it's not simply an attempt to avoid the time limit because there is no evidence of fraud, my view is that most courts will say, of course you can prosecute a fraud, it is a fraud. Okay, is that everything?
Well, I think there may be one or two other questions, I can't tell, but if there are, we will do our very best to get back to you by email when we can.
Well, that concludes our talk for today. Thank you very much for joining us on another edition of Gough Square Live. We'll next be broadcasting on Tuesday the 9th of May when the topic is digital disclosure, and we will hope to see you then.